Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Lots of news this week. Excellent Federal Bar Association conference in Arlington concluded. And perhaps in recognition, the Supreme Court decided to take up Chevron deference next term. Massive. And to do it in a case that Justice Jackson must recuse no less because I guess she was on the panel below before her elevation to the Supreme Court. There wasn't another D.C. Circuit case with this 40-year-old Supreme Court decision at issue for the court to take? Apparently not. And in some personal news, well, I, in tandem with podcast listener and excellent attorney Brandon H. Riches and his law firm, achieved a remand of the Ninth Circuit in the unpublished decision Amaya Pineda v. Garland, getting a win on nexus in a mixed motive asylum case. From the court, quote, "To the extent Mr. Amaya Pineda was targeted, as the BIA found he was, because gang members knew he had family in the United States, that tends to show Mr. Amaya Pineda's membership in his family was at least one central reason he was targeted," end quote. Even if, as everyone recognized, the persecutors were motivated largely by money rather than animus against the family. Godspeed to you on remand, sir. And now, to the published cases this week. First up is matter of Morales, published by the BIA, on a Friday, while I was at the Federal Bar Association conference in Arlington. And so, I am recording this case from a hotel room in Baltimore. If you've caught that those are two different cities, you are correct. This case is about procedure. Specifically, the BIA's. Specifically, the BIA's authority to decide appeals that are filed untimely, the nightmare of every appellate attorney. Here, the BIA has thrown us a life preserver, albeit under the guise of a harsh decision. In essence, this decision is a sheep in wolf's clothing. We don't know much about Mr. Morales and his family. What we do know is that an immigration judge denied immigration relief and ordered the family removed on December 13th, 2021. Notices of appeal are due 30 days thereafter to the BIA, and Mr. Morales' wasn't received by the BIA until January 13th, 2022. 1 day late. 30 days has September, April, June, and November, but all the rest have 31. Always trying to provide value on the pod. This notice of appeal was filed in paper because this is a paper case in immigration court. And counsel mailed the notice of appeal timely to the BIA on January 10th. But counsel did not pay for overnight delivery and instead used USPS. Counsel explained that this was inadvertent and simply a clerical error. They meant to send it overnight. But because they didn't, it arrived at the BIA 1 day past the notice of appeal deadline. And because of that, the BIA dismissed the appeal and affirmed the removal order, irrespective of the merits of that removal order. True, the regulations will extend the filing deadline to a Monday if the deadline to file falls on a weekend, but apparently that didn't happen in this case. Mr. Morales then filed a motion to reconsider with the BIA, and that's what's at issue here. In the 2006 decision matter of Liadov, the BIA held that the 30-day deadline to file a notice of appeal is jurisdictional, and that the BIA cannot extend it. Sure, it can take an untimely appeal on its own sua sponte, but it rarely does, and it can't extend the actual notice of appeal deadline and accept an untimely notice of appeal. But as we all know, we now live in the wonderful world of claims processing rules. And recently, many courts have disagreed with matter of Liadov, most recently the Fifth Circuit in Boxsaben v. Garland, episode 102. According to those courts, the regulation governing notices of appeal to the BIA, 8 C.F.R. section 1003.38c, is actually a claims processing rule and is not jurisdictional. The BIA has now agreed, and as such the BIA now, quote, has authority to accept what are otherwise untimely appeals and consider them timely, end quote, under certain circumstances. Matter of Liadov has been expressly overturned by the BIA. So what are the circumstances where the BIA will extend the notice of appeal deadline? Attorney victims of unexplained FedEx mismanagement are dying to know. Well, said the BIA, it's the equitable tolling standard used throughout immigration law. The BIA, quote, will accept late-filed appeals where a party can establish equitable tolling applies, end quote. Therefore, quote, a party must show two things. The first is that he has been pursuing his rights diligently. The second is that some extraordinary circumstance prevented timely filing. The party seeking equitable tolling must clearly establish both in the motion to accept an untimely appeal, end quote. So you gotta file a motion too. I'll also note that as the BIA appears to be adopting federal equitable tolling principles, don't be shy to pull case law from your circuit on equitable tolling standards and examples that will almost surely come from the motion to reopen context. That being said, quote, even an appeal that is merely 1 day late will not be considered timely unless the party can show both diligence in the filing of the notice of appeal and that an extraordinary circumstance prevented timely filing, end quote. But I mean, I would think that this case would at least meet the diligence standard, right? Because here the notice of appeal was in fact mailed timely. That's so diligent that it's actually on time. The BIA disagreed. To the BIA, the diligence clock begins ticking on day 1 of the notice of appeal deadline, and the respondents here hired counsel 5 days before the notice of appeal was due. Quote, they offer no explanation about what steps, if any, they took in the first 25 days to pursue an appeal, end quote. Even though, again, the notice of appeal was diligently and timely mailed. What matters is when it was received by the BIA. Not a categorical rule, though. Quote, although waiting until 5 days before the appeal was due to retain counsel is not necessarily a failure to pursue rights diligently, the respondents and their counsel have not sufficiently explained the steps the respondents took to pursue the appeal to persuade us that they acted with diligence, end quote. Okay. And the standard to meet. But also the BIA didn't see extraordinary circumstances, the second equitable tolling requirement. I'll just quote it all to give you a standard for when this horror show happens to you, counsels. Quote, ordinarily, an inadvertent act of choosing regular mail rather than a guaranteed next-day delivery is not an extraordinary circumstance. An extraordinary circumstance may include those situations where reasonable expectations about an event's occurrence are interrupted. One example is where a party uses a guaranteed delivery service and the service fails to fulfill its guarantee, end quote. Heck, is that even FedEx overnight? They, after all, don't guarantee overnight service. What is that even? Allow me to plug Ben Winograd's day of BIA filing service. Now, the BIA isn't blind to the harshness of its holding here. But citing to the Supreme Court, the BIA explains that, quote, filing deadlines like statutes of limitations necessarily operate harshly and arbitrarily with respect to individuals who fall just on the other side of them. But if the concept of a filing deadline is to have any content, the deadline must be enforced, end quote. By the way, it looks like petitions for review to the circuits are jurisdictional, those deadlines, and there are no exceptions there. So the BIA's framework in this decision does appear to be more favorable than the circuits. To the BIA, quote, a party who waits until nearly the last day to file an appeal does so at their own peril, as the equitable tolling exception will not apply automatically to excuse appeals that are filed one day late, end quote. Mr. Morales and his family lose and may get physically removed without substantial appellate review on the merits. If I may. To the extent that anyone from the BIA is listening to this podcast, allow me to alert you to an issue. We are thankfully moving to electronic files and filing of removal proceedings and litigation of these matters and notices of appeal through e-case. All praise to Falls Church. However, and unless I'm missing something, it remains the case that if an attorney did not represent the non-citizen at the IJ level, but has been hired for the BIA appeal, there exists no way for the attorney to file the notice of appeal through e-case. Instead, the attorney must file a paper notice of appeal, which is insane, particularly in the world of e-case and given this decision and how all other courts operate. What's more, the BIA's Notice of Appeal instructions technically require e-case appeals of e-case cases. So the attorneys coming in for appeal are in the unenviable position of violating the BIA's rules from the onset, only because the BIA has not provided a way to comply, and with only the assurance of a helpful BIA help desk employee that everything will be okay. Not to mention that only through e-case can attorneys access the very necessary EROP. With the 30-day deadline so important, as this decision makes clear, an ability for attorneys that are coming in only for appeal to file their notices of appeal through e-case would be much appreciated. Many thanks in advance. And that is matter of Morales. Next is Rangel Perez v. Garland, published by the Fifth Circuit on May 2, 2023. This case is about cancellation of removal. Mr. Perez is from Mexico and apparently entered the U.S. unlawfully at an unknown date and time many years ago. What we do know is that DHS initiated removal proceedings in 2011, charging Mr. Perez as being present in the United States without admission or parole. Now, Mr. Perez has a U.S. citizen wife and 3 minor U.S. citizen children, and he claimed that his removal would cause exceptional and extremely unusual hardship to all of them. Only need one, though. But anyway, he applied for non-LPR cancellation of removal under I&N Section 248B to try to remain in the U.S. Interesting aside. If the Fifth Circuit is saying that they don't know when Mr. Perez arrived, I wonder how he established that he's been in the U.S. for at least 10 years as non-LPR cancellation of removal requires. Well, although the decision doesn't say, the 2011 NTA helps. That at least puts a pin in the date in 2011 at a minimum, and if the NTA was deficient, as I bet it was, then the 10-year clock never stopped in light of Supreme Court precedent, so he could establish the 10 years. Just a thought. Not what this case is about. Mr. Perez's youngest daughter suffers from asthma, and he submitted other medical records as well, but the IJ held that it didn't suffice to establish the hardship required for non-LPR cancellation. Mr. Perez challenged that on appeal and filed a motion to remand for consideration of new evidence as well. His wife was now pregnant with their 4th child, and another daughter was, quote, being treated for ADHD, evaluated for speech deficiencies, and placed in special education classes, end quote. All would appear at least material to a hardship analysis, if maybe not dispositive, who knows, particularly as there was no final order of removal yet, with the case pending on appeal to the BIA, so Mr. Perez didn't have to get over the motion to reopen standards, necessarily. The BIA, however, quote, concluded that a remand was not warranted because the new evidence would not change the result in the case, end quote. To the Fifth Circuit we go, both for the direct appeal and on the denial of the motion to remand. Kind of. Because the direct appeal is pretty much dead in the water after Patel. And it's pretty bad. According to the Fifth Circuit panel here, in the 2022 decision Castillo-Gutierrez v. Garland from episode 119, an 11-case monster of an episode that occurred as I was also moving houses, the Fifth Circuit has already, quote, understood Patel to categorically foreclose review of hardship determinations, end quote. I'm not bitter, you're bitter. And it gets worse. Because of that, quote, it follows that we also lack jurisdiction to review the BIA's decision not to remand to the IJ to consider new evidence, end quote. I disagree, but also that doesn't matter at all. But so do a bunch of other circuits, cited in a very large footnote in this decision. Perhaps because of that, the Fifth Circuit assumed arguendo that it could review Mr. Perez's arguments and rejected them on the merits. Assuming that Mr. Perez had properly argued that the IJ and the BIA misapplied a legal standard to undisputed facts, and assuming that the Fifth Circuit could review such an argument even when tethered to discretionary relief like non-LPR cancellation of removal, the Fifth Circuit saw no error in what the IJ and the BIA had done. Quote, contrary to Mr. Perez's assertions, the IJ and the BIA thoroughly considered each of his hardship arguments and applied the appropriate legal standard. The BIA also considered the new evidence presented by Mr. Perez, but concluded that this evidence was unlikely to change the IJ's decision. End quote. The Fifth Circuit, therefore, denied Mr. Perez's petition for review. Is the Fifth Circuit splitting with many circuits to hold that it can't even review the application of a legal standard to undisputed facts when the underlying application is non-LPR cancellation of removal? And is the Fifth Circuit similarly holding that it can't review misapplication of a motion to remand legal standard when tethered to non-LPR cancellation? Sure seems like it, but also the Fifth Circuit kinda hedged. But that won't stop citations to this decision, should our worthy adversaries in DC so choose. So I'm giving it a gong. And that is Rangel Perez v. Garland. Also, while we're with the Fifth Circuit, this week the Fifth Circuit amended its Zamora-Silvero v. Garland decision, episode 149. The court is still unsure whether Texas Transportation Code section 550.021A4 is a CIMT, and whether the failure to remain at the scene of the accident and provide one's name and other information is morally turpitudinous. And I still suspect it's not. And the case is still going back to the BIA for a determination in the first instance. But the decision has changed a bit, so I note it, and check out episode 149 for a bit more. More cases in just a minute. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651 and tell them who sent you. Next is Oxlaj v. Garland, published by the 8th Circuit on May 3, 2023. This case is about nexus. Mr. Oxlaj is an auto mechanic from Guatemala. He applied for asylum and related relief in immigration court, testifying that he was robbed at knife point on a bus in Guatemala in 2013 by individuals who it seemed were in a gang. Mr. Oxlaj filed a police report, providing his phone number with the report, and the next day he received a call. But it was not the police. It was someone, quote, threatening to kill him for going to the police, end quote. Mr. Oxlaj got a new phone number, but received a call a few months later, threatening to kill him unless he paid money to the caller. 2 days later, 3 men tried to kidnap Mr. Oxlaj, something that he also reported to police. But very shortly after that, he fled to the United States in fear. Quote, while in the United States, Mr. Oxlaj learned that a letter was left outside his grandparents' house, where he had lived in Guatemala, demanding money and threatening him as a consequence for filing a police report, end quote. So then, as the basis for his asylum claim, Mr. Oxlaj argued that he had suffered past persecution in Guatemala for his anti-gang political opinion and for his membership in the particular social group of witnesses who cooperate with law enforcement. Believing Mr. Oxlaj, the immigration judge nevertheless denied by making a no-nexus finding. Those weren't the reasons Mr. Oxlaj was persecuted, but rather because the gang members wanted money. Sounds familiar? The BIA affirmed. And here, the 8th Circuit did too. And by the time it got to the 8th Circuit, it wasn't so much about nexus per se, as it was about the cognizability of the asserted protected ground. The 8th Circuit affirmed that the proposed particular social group of witnesses who cooperate with law enforcement lacks social distinction and particularity. Those are 2 of the requirements required of particular social groups, and the 8th Circuit found them lacking here. Now, as always with cases like this, Mr. Oxlaj tried to rely on the seminal 2013 9th Circuit decision Enriquez Rivas v. Holder, which had found a similar particular social group cognizable. But the 8th Circuit distinguished that case and its prior precedent here. In this case, to the court, Mr. Oxlaj, quote, has presented no evidence that Guatemalan society recognizes witnesses who cooperate with law enforcement as a socially distinct group, end quote. The BIA's social distinction framework now requires a dive into the views of a society abroad, and Mr. Oxlaj didn't make it here. Pretty tough to do in any case, especially without an expert witness to explain the views of a society. No discussion, though, of Mr. Oxlaj's anti-gang political opinion. I wonder why. Although the 8th Circuit did uphold some factual findings that, as upheld, might have made it hard or impossible for Mr. Oxlaj to establish that he actually held such a political opinion. I don't know. Unclear and undiscussed. But Mr. Oxlaj did not succeed in this short case. And that is Oxlaj v. Garland. Our final case this week is Turcios-Flores v. Garland, published by the 6th Circuit on May 5th, 2023. Friday. This case is about particular social groups. Let's jump into this complex case to end the episode. Ms. Turcios-Flores is from Honduras and operated 2 merchant stands in the Honduran capital with her husband. Like all the other merchants in the capital's Cologne market, Ms. Turcios-Flores and her husband had to pay MS-13, a war tax, to avoid being killed and to continue to operate their stands. But in 2012, the husband inherited a farm in a rural part of the country and hid that information from his MS-13 extorters. But a cousin knew, and that cousin joined MS-13 that year. And the cousin told. And so MS-13 began demanding extortion at an amount of 100 times more than they had before, or they'd murdered the husband. So the husband fled to the US, hoping that it would end the threats to the family. 2 months later, however, the gang turned on Ms. Turcios-Flores herself. And she began paying all the money demanded, who knows, maybe assisted by money sent back from her husband in the US. Speculating. But it still didn't stop. MS-13 increased this already heavy demand 5 times more, threatening to murder Ms. Turcios-Flores' children if she didn't pay. quote, with few other options available to her, end quote, Ms. Turcios-Flores fled to the U.S. with her 2 young children. That's not a trip by plane, by the way. Caught at the border and placed in removal proceedings, she and her children applied for asylum and related relief and protection. Both the immigration judge and the BIA denied. The Sixth Circuit, however, did a few things. As we all know, asylum requires a fear of persecution on account of one of the 5 protected grounds, and in cases like this, it's usually a particular social group-based claim. The first step there is to show that the non-citizen is actually part of a recognized particular social group. Here, Ms. Turcios-Flores put forth 3 proposed social groups, because remember, there's no limit to the amount that you can assert before the IJ. 1. Rural landowners or farmers. 2. Single mothers living without male protection. And 3. Members of her husband's family. Whether a particular social group is cognizable is a 3-factor test. The group must be immutable, particular, and socially distinct in the country at issue. Immutability is usually the easiest one to wrap a head around, at least to me. Being gay, for example, is immutable, as it's something that someone shouldn't be expected to change. In this decision, the BIA had dismissed the group of rural landowners or farmers as not immutable. But in the 2010 decision, Biexia Quinn v. Holder, the Sixth Circuit explained that, quote, the shared characteristic may be immutable or fundamental, meaning that it must be one that the members of the group either cannot change or should not be required to change, because it is fundamental to their individual identities or consciences, end quote. Emphasis by the court. And that's a bit broader of a definition, isn't it? And directly on point, the Sixth Circuit also recognized in that decision that a basis, quote, might be a shared past experience, such as landownership, end quote. Ending the logic with a bomb of a holding, while landowners won't always qualify in every country, quote, Honduran landownership is a fundamental characteristic, end quote. Period. It is fundamental to those who have it in Honduras, and Honduran asylum seekers shouldn't have to change this characteristic to avoid harm. To be cited in all similar cases. The BIA kind of found otherwise in the 2020 decision matter of ERAL, albeit with Guatemalan landowners. But this is Honduras, and in any event, the Sixth Circuit expressly does not care. Although immutability is only one of the elements of a particular social group, it was apparently the only one relied upon by the BIA to deny asylum based on the landowner particular social group. So the Sixth Circuit remanded for further correct analysis. But the group might ultimately fail for other reasons. Who knows? So the Sixth Circuit turned to the second group, single mothers living without male protection. Usually a good idea to propose more than one particular social group. The BIA denied this group based on social distinction, or a believed lack thereof. The record compels otherwise, said the Sixth Circuit, quote, first, the police in Honduras distinguish single mothers like Ms. Turcios-Flores from a broader category of people vulnerable to persecution. The deputy commander of the Honduran National Police explains that gangs are identifying vulnerable people, for example, women who have children with their husbands in the U.S., end quote. Great arguments and great record being made here. When the police identify a group as vulnerable, that is strong evidence that the group is viewed differently in a society, here, Honduras. And unlike other groups rejected in the past by the Sixth Circuit, this one isn't impermissibly defined by the risk of persecution, like, say, young Salvadorans who have been threatened in the past. This one is simply narrowed by marital status. Quote, it just so happens that these characteristics also make them more vulnerable to extortion, end quote. And that's fine, said the Sixth Circuit, accepting a fine line argument. But aren't they all with particular social groups? Because after all, while she was targeted while in the market, the quote, extreme threats, end quote, only began against Ms. Turcios-Flores after her husband left for the United States. And so again, in what appears to be a bomb of a quote for all these cases that arise during the same time, quote, single mothers living without male protection is socially distinct, end quote, in Honduras. Remanded for further analysis there, too. Please continue, Sixth Circuit. It did, but the party's a bit over. The last proffered particular social group was the family-based one. And yes, of course, family-based PSGs are often cognizable under immigration law. But whether that was one central reason for the persecution, the nexus required of asylum, is another question. Here, quote, the record included no indication that Ms. Turcios-Flores' connection to her husband's family singled her out for gang-driven persecution, end quote. So the family-based claim is out. But of course, Ms. Turcios-Flores has the other particular social group-based claims to rely upon on remand. Then there's withholding of removal. The Sixth Circuit is one of the circuits, like the Ninth Circuit, where the nexus element is easier to satisfy for withholding than it is for asylum. In the Sixth Circuit, rather than having to be one central reason for the persecution suffered or feared, withholding of removal only requires that a protected ground be a reason for the persecution suffered or feared. All other burdens are higher for withholding, but not nexus, because of how the statute is written. It becomes a problem when IJs, like here, rely on a, quote, asylum application's nexus determination to make the withholding of removal application's nexus determination because the two analyses are distinct, end quote. And it's kind of what also occurred in the Amaya Pineda decision that I mentioned at the top of the episode. It appears that the IJ did not conduct the correct withholding of removal nexus analysis, and that the BIA tried to clean it up correctly on appeal. But the IJ never made the distinct a-reason factual finding for withholding separate from asylum. So the BIA can't clean up a factual finding that the IJ never made. In fairness to the IJ, this wasn't an error at the time, because the Sixth Circuit adopted the different a-reason nexus standard for withholding, while this case was on appeal to the BIA. But that doesn't change the fact that now it is a factual error. So remand, seemingly all the way back to the IJ, right? Because the BIA cannot make factual findings. The Sixth Circuit affirmed the denial of Convention Against Torture Protection, though. For CAT, if the torturer isn't the government, there must be a showing that the country's government consents or acquiesces to the torture feared, but the record here showed the opposite. Quote, Honduras is trying to prevent gang violence and extortion, even if it failed in Ms. Turcios-Flores' case, end quote. Notice the implicit recognition in this decision, though, that extortion is persecution and torture. So, mostly remanded. A big congratulations to Justin S. Fowles and Samuel W. Wardle for petitioners. Big win. A bit more from the concurrence and dissent before we go. Judge Chad A. Riedler concurred and dissented. And at first I did a double take, because I've gotten used to seeing him on the other side of these decisions. Judge Riedler was the head of the Department of Justice Civil Division during many of the Trump years, meaning that technically he was the head of oil and was always listed for the government in these immigration cases. I was not aware that he was now a circuit court judge on the Sixth Circuit appointed by President Trump. And this is the first time that I've seen his name as a judge on a Sixth Circuit immigration decision, so let's see where his mind is at on these issues involving his former office. Judge Riedler is not here for the landowner or the single mother stuff. Or that is to say, Judge Riedler jumped past cognizability and went straight to nexus, believing that these groups weren't why Ms. Turcios-Flores was targeted. Judge Riedler sees this case as one motivated almost entirely by Ms. Turcios-Flores' wealth, which he does not deem a cognizable, particular social group characteristic. So it appears that Judge Riedler concurs in the parts denied and dissents in the portions favorable to Ms. Turcios-Flores. And that is Turcios-Flores v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.